Good day, welcome to yet another video edition on our Law of Evidence series. We've looked at many other types of evidence and how they are admitted, and this time we're looking at fundamentals of admissions and confessions in South African Law of Evidence. If you have not already subscribed to my channel, I ask you to do so, because that promotes the channel, helps it to grow, and then it also helps me to grow and get at least a benefit from the work that I do. So remember to like the video, to share with your friends, to subscribe, to hit that notification bell, so that in future when another video is shared, you can get to be notified on time. So we are looking at admissions and confessions, and we are saying to ourselves, what are they? Now, in an attempt to answer, we say admissions and confessions are statements emanating from the person who is a party to the issues in a court. And these statements are detrimental to the person making them. It's going to be clear as we proceed in the discussion, but take note that these are statements made by people who are parties to the issue or parties to the dispute. And then obviously the statement is not favorable to the person making it. In other words, it's detrimental to them. The statement must be relevant to the facts in issue in order to be admissible. And then admissions and confessions are similar, and yet they are different. You will notice the difference as we proceed. A confession is an admission of all the facts in issue, but an admission is in respect of certain facts in issue and not all the facts in issue. Again, we are going to illustrate these issues in the course of the video. Now, their difference is in the degree and not in the nature. In other words, they are different. In fact, they are similar, but the difference is not in their nature. It's only in the degree of the confession or the admission. Now, the rules determining the admissibility of the confessions differ from the rules determining the admissibility of admissions. So you must take note of that. And admissibility of confessions and admissions is subject to section 217(1) as well as 219A and 220 of the Criminal Procedure Act 51 of 1977. Now, we are going to look at examples below, so don't really you shouldn't really panic at the moment. Now, what is a confession? A confession is an unequivocal admission of all facts in issue, equivalent to a plea of guilty, and an admission of guilt in a criminal trial. In other words, when a person makes a confession, it is sufficient on the basis of the confession for the court to then convict the accused if it is a criminal trial. It does not contain any exculpatory or self-exonerating element in itself. In other words, a person who makes a confession tells the court that they are indeed guilty of the offense. They don't try to exonerate themselves or to exculpate in any kind. So if the statement is of such a nature that it requires a careful and laborious scrutiny by the court before the court can infer guilt, then it is not an admission. It's not a confession, but it's an admission. In other words, a confession admits everything, whilst an admission is only in respect of certain elements of the offense. We are saying it is unequivocal, it is without justification. So in earlier jurisprudence in R versus Becker in 1929, the judge was de Villiers, and this is what Judge de Villiers said. In fact, he held that a confession could only mean an unequivocal acknowledgement of guilt. the equivalent of a plea of guilt before a court of law. So if somebody confesses, they are literally saying, yes, I admit all the elements of the crime have been satisfied, I am guilty, you may go ahead and convict. That's what a confession amounts to. So it may be made expressly, though it need not always be made expressly. And it can sometimes be inferred from silence, though of course that's very problematic when one looks at the fact that Section 35 of the Constitution of South Africa of 1996 implies that in terms of the right to remain silent and the presumption of innocence, you may not convict somebody of an offense just because they have been silent, because then that would be a violation of the right to remain silent. The accused has that right to remain silent in the course of the trial, so that is in keeping, of course, with the principle of presumption of innocence, and that's very, very important to take note of. But we are saying a confession is equivalent to an admission of guilt in a sense, and that's how the court in Rex versus Becker determined in 1929. So the question is, do people ever make any confessions in court? People do not usually make express confessions in court. It's very rare. So the confession must be made in respect of all the definitional elements of a crime. We have already said that a person who says, I took the TV receiver, does not make a confession, but just an admission that they took the receiver. But the one who says, I stole the TV receiver, does make a confession, because then it's an equivocal admission of guilt. He's saying, I stole. Is admitting to the fact that stealing is a crime. In fact, taking without the permission of the owner is a crime which amounts to theft. So he's admitting to all the elements of unlawfully taking what belongs to another person without their permission in an unlawful way. The reason is that a person who took a television receiver may have acted with grounds of justification or under a misapprehension that the act was lawful. So if the person says, I took the TV, maybe they were mistaken, they thought it was their own, or they thought they had the permission to take it. But when a person says, I stole, then it's a different ball game. So a person who admits to stealing the TV receiver admits to all the elements of the crime of theft. Hence, a competent conviction may immediately follow. Admissibility depends on whether the party making the confession did so with the intention or the confession was inadvertent. So it is inadvertent if it's not intended. So if it's not intended to be a confession, then it may not be admitted as a confession, because then the court may need to interrogate the witness further in respect of the issues. So in case law, we've got quite a number of examples of confessions. For instance, the S versus Yende in 1987, or the S versus Groove Michel 1975, or the State versus Nyembe in 1982, as well as the S versus Lata in 1994. How about the case of the State versus Mofokeng in 1982? So what happened in respect of these cases? In the end, the court held that in deciding whether a statement amounts to a confession or an admission, it applies an objective test. In other words, it doesn't matter whether the accused believes he is confessing or admitting. The court will look at the statement objectively to determine whether, from the look of things and judging from the statement itself, is it a confession or it is an admission. And the intention of the person making the statement was said to be an element of the surrounding circumstances, which can be taken into account, but it's not the determining factor. So if somebody thought they were self-exonerating, but they ended up without intention, inadvertently admitting to facts, then it may be taken as a sufficient confession, upon which a conviction may then ensue. In the State versus Groove Michel 1975, the statement which was made by the accused saying, "I shot her full of holes," was held to be a confession because it was open to the accused to raise a defense. In fact, it was not a confession, rather, it was an admission, because it was open to the accused to raise a defense which could exculpate him. For instance, he could have said he shot her full of holes, but in self-defense. That would have been sufficient. And then S versus Nyembe also deliberated on these issues, and in S State versus Latta 1994, it was stated that the state bears the onus of proving that the confession was made freely and voluntarily in conformity with section 217 1B of Act 51 of 1977. So you may have to go and read section 217 1B. It says the statement must be made freely and voluntarily without pressure being brought to bear or any intimidation or all kind of manipulation upon the person making the statement. So if there is evidence that there was manipulation or there was threat or use of force and so on, then it does not amount to a confession. The court will not admit it as a confession. And then in the State versus Mufokeng 1982, paragraph 149, the court held that in respect of crimes which require the mens rea in the form of dolus or culpa, so an admission of the actus reus does not create a confession, even if it is prejudicial to the person making it. So in other words, a person may admit to having committed the act, but the unlawfulness, the culpability element, must still be determined. In other words, the culpability, whether the person did it with intention or negligently, depending on the type of mens rea required, the court may still have to establish those issues by itself through maybe further interrogation, asking questions, and so on. So you find that admissions in South African courts constitute a statement or conduct adverse to the person from whom it emanates. So we've already said that regarding the confession. So it is adverse to the person from whom it emanates, and it places the person in a disadvantage. And the statement may be made orally or in writing. So one may write an admission, or even just through normal conversation, a person may make an admission. So it may be oral or it may be in writing. It is relevant since it is the admission of some and not all the facts in issue. So it's an admission of some facts relevant to the issue, but it does not, it's not the same as a confession where somebody says, "I murdered" or I stole. In this particular case, when somebody says, "I took the television set," they are admitting. So the three key elements are the statement or the conduct, which is adverse to the person making it. In other words, it's detrimental. So when it's eventually admitted by the court and applied, it does not serve the interest of the person making the statement. In fact, if it's the accused who has made such a statement, they get to be convicted on the basis of it. So that's why we are saying it is detrimental to the person making it, or it is adverse to the person making it. So the nature of the statement or the conduct is very important. The statement is an oral utterance or it is a written communication. There have been questions to say, can it be maybe in the form of conduct, just by pointing. Yes, through conduct, some conduct, it may amount, of course, to an admission or to a confession. For instance, a pointing out of stolen property hidden behind the bushes. So if a television set has been stolen from a house, and the accused is a suspect is confronted by the police or by whoever, and then the person goes to show them where the television set is hidden behind the bushes, that on its own is actually a statement, so it is a conduct. So it is important and relevant in the sense that it is the accused who knew where the television set was, and he or she is the one who led the police to that place and ensured them where the television set had been hidden. So in that case, then you find that that accused is actually made an admission or a confession, whichever the state might be. And then the communication is detrimental to the party making it, and it may also emanate from a third party, as we are going to see later on when we discuss the impact of vicarious admissions. We discuss them below. But so we are saying the statement emanates from the person who's privy to the developments and who's a party to the proceedings. But sometimes in certain circumstances it may be made by a third party. We're saying conduct which does not amount to communication but which is detrimental to the person from whom it emanates is circumstantial evidence. For instance, an attempt to run away when one sees police approaching their home. That one is not a confession or admission, but it is circumstantial evidence, because then police begin to ask themselves the question why one is running away just as they see them approach. Silence may constitute an admission. That was decided in Jacobs versus Henning in 1927, whereby the defendant kept quiet and lowered his head on being accused of fathering a child. But if it's criminal proceedings, as we said earlier, the right to remain silent in terms of Section 35 of the Constitution remains very relevant as an aspect of presumption of innocence. So courts will be very reluctant and hesitant to infer guilt from silence of the accused in criminal trials. That's very important to remember. So there are different types of admissions. We have intentional admissions, which are objective and not subjective. Rather, we use an objective test to determine whether one has made an intentional one has made an admission in the first place. So even if they did not intend to make an admission, but if objectively the statement amounts to an admission, then it will be admitted as such. So it is irrelevant whether it was meant to be self-exonerating or exculpatory or not. So we have formal and informal admissions in respect of that also, and we have a distinction between the two. It's very, very important to distinguish between formal and informal admissions, because people may formally admit, sometimes they don't admit formally. So that's very, very important to consider. So in respect of formal admissions, in civil proceedings, the law is that in terms of Section 15 of the Civil Proceedings Act 25 of 1965, it shall not be necessary for any party in any civil proceedings to prove, nor shall it be competent for any such party to disprove any fact already admitted. So in other words, if one of the parties admits during proceedings, then the other party does not need to prove anything in connection with that, because the admission itself is sufficient. So it's not necessary to adduce evidence to prove a fact formally admitted on record. That is what is already on record before the court. And facts may be admitted during pleadings, so as the parties exchange the pleadings, one party may admit to another to a certain fact, so it becomes common cause once there is such an admission. So a formal admission does not have to be proved by the party in whose favor it is made, as it forms part of the record of the court. In the Wild Sea Construction case versus Van Vuren in 1983, the court held that the plaintiff is absolved from the onus of proof of an admitted fact on pleadings. So if one of the parties already confirms through pleadings that a certain state of affairs exists, then there is no need for the other party to prove, maybe by way of evidence or not, because already once that statement is on record before the court in terms of in the court papers, then it is already admitted. There's no need for it to be proved by leading evidence. But sometimes a party may want to withdraw certain formal admissions that they have made. For instance, the defendant may apply for leave to amend a plea or to withdraw a formal admission. So under such circumstances, the court will grant the leave to apply in very exceptional circumstances. For instance, in the Affordable Medicines Trust and Others versus Minister of Health in 2006, the court held that amendments will always be allowed unless the amendment is in bad faith, that is mala fides, or unless the amendment will cause an injustice to the other party, a kind of injustice which cannot be cured by any appropriate order for costs. And we are saying unless the parties cannot be put back for the purpose of justice in the same position as they were when the pleadings which are sought to be amended were filed, so the court may refuse to grant such an order permitting amendment of the plea or withdrawal of a formal admission. So we are saying the withdrawal of an admission in a plea must be properly motivated and justified. So we may follow the case of J.R. Shanish versus W.M. and many others. Even in Amot versus South African Mutual Fire and General Insurance, the court, as per Leon J., held that there is need to consider the questions of prejudice to the other party. So withdrawing a formal admission or amending a plea will be permissible if it does not prejudice the other party, because the interests of justice must always be taken into consideration, and sufficient explanation must be satisfactory. It must be in good faith to show how maybe prejudice or injustice will not occur to the other party who stood to benefit from the formal admission that had already been made. So we are saying withdrawal could be considered if it is not prejudicial to the other party. In criminal proceedings, formal admissions also get to be dealt with in terms of Section 112 of the Criminal Procedure Act 51 of 1977, where we are saying an accused may be convicted on the strength of a guilty plea in terms of Section 112. So in that case, if the accused pleads guilty, pleading guilty, as we saw in the case of Rex versus Becker 1929, it is equivalent to an admission of guilt. Therefore, the court may proceed and convict. The court normally questions the accused after the Section 112 plea of guilt to satisfy itself regarding, the accused is guilty. Did really, because some people just admit when they are not guilty for some reasons, maybe to cover up for the real perpetrator. Because you can imagine if one is accused of murder and they plead guilty, even if you found the real perpetrator in future, it may be difficult to convict them, because already if one person is murdered, it may not be appropriate to unless they acted in common purpose, that kind of thing. So some people admit to offenses that they have not committed, just because maybe they want to cover up for some friend or somebody else. So the court normally questions the accused after the Section 112 plea of guilt. And then admissions made by the accused in terms of Section 112 stand as proof of the allegation in terms of Section 113. And then the Section 112 admissions are formal in nature and place the fact beyond dispute. An accused who pleads not guilty may explain her plea in terms of Section 115. And sometimes in the process of explaining the plea of not guilty, there may be a mixture of exculpatory remarks together with those that are, incriminating admissions. So these will be admitted in terms of Section 120 with the consent of the accused. In other words, the court will have to verify by questioning the accused regarding these admissions. And if the accused admits that yes, this is an admission I'm making, then it may be recorded as a formal admission in terms of Section 220 of the Criminal Procedure Act. And once it is admitted in terms of Section 220, then it is sufficient fact of the particular fact alleged. If it's part of a statement which is admitted, rather, if part of a statement is admitted and the accused has the right to have it reviewed as a whole, to have it viewed as a whole. So if an accused makes a statement and then that statement is admitted, then the whole statement must be admitted, which means the parts that are self-exonerating and the parts that are incriminating, self-incriminating, that is, must be looked at as a whole. The court may not pick and choose within the same statement whether to accept one part or the other. So it must admit everything and view the whole statement in its total context. Earlier on, we spoke about what we called vicarious admissions, whereby we said that some people could end up, third parties could make statements in terms of which persons who have not made the statement could end up being held accountable. And we call those vicarious admissions. We are saying an admission by a third party would be acceptable against the standing principle that an admission is admissible only in respect of the person making it. So a third party's admission is hearsay, and its admissibility is subject to Section 3(4) of the Law of Evidence Amendment Act 45 of 1988. We've got a video on hearsay evidence. You may visit that one just to refresh your memory on what we discussed there. But we are saying vicarious admissions are admissible in exceptional circumstances where two parties share privity of interest or obligation. For instance, it could be on the basis of express or implied authority, as in the case of agents and their servants, or in the case of employer-employee, in the case of partners, whether in a business partnership or in a marital union, we could be talking about legal representatives, the client, the lawyer, that's the client, and the attorney privilege, rather a relationship where a client then authorizes his or her attorney or advocate to make certain admissions. So as a legal representation, such admissions are taken as vicarious, because the person making the admission is not the one against whom it operates. And then, so we're speaking about spouses and referees in some instances. And we are saying evidence by a director of or a trustee in an insolvency proceeding or in a similar inquiry under company legislation is not binding on others. So if one director makes an admission, it is not necessarily binding on others. It cannot be held as a vicarious admission, maybe against the principal. So the basis for admissibility of vicarious admissions is the privity or identity of interest between the two parties. For instance, when you look at the spouses, it may be in their interest. Remember, a statement which is detrimental to the interest of one spouse would usually be detrimental to the interest of the other. So by the fact of privity of identity or of interest that is present in spouses, you may find that the admissions or utterances, the statements made by one spouse, are actually admissible in respect of the other spouse. So, or we're talking about predecessors and title, people who have bought and sold property to each other, or in the case of master-servant relationships, even in the issue of nominal and real parties. So in those kind of relationships, you find that vicarious admissions are admissible in court, made by a third party and binding a party who has not made them. But for the reasons discussed here, the statements then gets to be admitted. And then we have another set of statements which we call statements without prejudice. So these are statements which are made by parties to an issue pursuant to a settlement of a dispute. So you may find that a dispute exists between two persons, and then they decide that maybe instead of taking the matter in the legal or litigation kind of fashion, they are rather going to, have an out-of-court settlement where they are going to discuss the matter, maybe in pursuit of alternative dispute resolution strategies. Remember, we have got your reconciliation, you got your arbitration, and you got your, what did I say? Conciliation, arbitration, and which is the other one? Mediation. So they can then place a disclaimer, that is, the parties may make a disclaimer to say, to the effect that if the statements made during the negotiation or the settlement negotiations, if the negotiations collapse, in terms of that disclaimer, the statements made, admissions and confessions made during the negotiations will not be admissible in court as evidence as between the two parties. So this disclaimer is necessary in order to encourage non-litigious settlements of disputes rather. So we are trying to encourage parties to seek resolutions to their disputes without necessarily taking these matters through litigation and court process. So we are saying they can go ahead, meet, and try to resolve the issues on condition that the statements that they make actually enjoy a kind of privilege, whereby we are saying if the negotiations collapse and do not result in a final settlement of the dispute, and the dispute now has to go to court, all statements, admissions, confessions made during the abortive discussions will not be admitted as evidence in a court of law. So that's the rationale for these statements without prejudice. Now, we have discussed these issues and we've come to the conclusion about them. And we are saying that confessions and admissions are communication emanating from persons who are parties to the issue, and the statement tends to be detrimental to the person from whom it emanates. And we are saying the difference between the confession and an admission is not in the nature of the statements, but it is in the degree. As we rightly pointed out, a confession is an admission of all the facts in issue, and it is equivalent to an admission of guilt or a plea of guilt in criminal proceedings. Whilst an admission is a partial recognition as true some of the statements or some of the elements of the dispute. We have said that in a case of a crime committed where there is the actus reus and the mens reus, where we have act and culpability as elements, and we are saying where intention is required or where negligence is required, the person making these statements must admit all the elements in order for it to be a confession. So in other words, if somebody says I caused the death of so and so, but it was not my intention, so then that would not be a confession for murder. It would only be an admission partially of the fact that their actions caused the death. But whether it is murder, it is culpable homicide, or none of those, it will then have to be determined by way of establishing whether the mental element of the crime has been satisfied. Thank you very much once more for being part of this presentation. Remember again to like, to subscribe, and to share with your friends. Thank you very much. Looking forward to meeting you in another video next time. Bye-bye.